Hello and a very warm welcome to Thorough Newspaper Analysis, which is presented to you by LawSikho. Now, for today, we have two editorial pieces to discuss, one of which talks about how safe harbor is at risk, and the second is about adultery as misconduct and judicial musings. This is going to be followed by news updates, and that is going to be followed by legal news. Now let's proceed. So I'd like to make here a mention of the fact that LawSikho hosts a daily quiz which is based on the DNA of the previous day, and the link for attempting this quick quiz, it is made available to you every day in the morning 8 a.m. in your WhatsApp and Telegram groups, and this quiz is open till 11 a.m. We would highly encourage all of you to attempt the quizzes. Let's proceed with the first editorial, which is safe harbor at risk. Essentially, safe harbor is a concept whereby the internet intermediaries, they claim immunity from liability arising out of the posts which are made by their users on these platforms, provided these internet intermediaries, they follow the compliance mechanisms that are in place for them. See, while putting out the proposed Digital India Act of 2023, the IT minister tried to term this act as a robust mechanism, a replacement for the obsolete Information Technology Act of 2000. The question on safe harbor, it is significant, the editorial adds, since the government has been trying to increase the compliance burden on the internet intermediaries through IT rules of 2021 and the later amendments which were made to these rules. In 2023 Jan, the IT Ministry proposed an amendment on the takedown of social media and news content that has been marked as fake or false by the Press Information Bureau or any other government agency. These, in sum, the editorial ads, have already put the safe harbor protections for these intermediaries at much risk. Further, the editorial asserts that it must be noted that social media intermediaries and the digital news media, they have an important role in regulating hate speech and misinformation. The IT rules specification on giving users prior notice before their content is removed and their access is disabled, the editorial terms that these are well taken. And it further adds that this means that social media platforms should not shut down user posts except when the same is required in order to maintain public order. There is a legitimate concern, the editorial adds, that the government is keener on regulating or taking down critical opinion or dissent in social media or news platforms than regulating free speech, hate speech, or misinformation. While making compliance requirements mandatory for the social media intermediaries, the editorial proposes that care should be taken to ensure that the concept of safe harbor is not whittled from the very core, and compliance made burdensome on social media intermediaries that should also be taken care of. Now let's proceed to the next editorial, which is titled as Adultery as Misconduct and Judicial Musings. The editorial starts by adding that more than 4 years ago, adultery was decriminalized by the Honorable Apex Court in the case of Joseph Shine versus Union of India, wherein it was held that Section 497 of the IPC and Section 198 of the CRPC was unconstitutional since they violated Articles 14, 15, and 21 of the Indian Constitution. The union sought clarifications from the court, saying that any promiscuous or adulterous act, it should be allowed to be governed by relevant sections of the Army Act, the Air Force Act, and the Navy Act, being special legislations by virtue of Article 33 of the Indian Constitution. Now, it needs to be noted and understood that this particular article, it empowers the Parliament to restrict or abrogate fundamental rights of certain categories of persons, including members of armed forces, to ensure proper discharge of their duties and maintenance of discipline. The court said that recently, in the case of Joseph Shine, it was not at all concerned with the effect and operation of relevant provisions. This is what the Apex Court said, that in this particular case, it was not concerned at all with the effect and operation of relevant provisions, and that it was not as if this court approved of adultery. And the Apex Court further added that it found adultery as a ground for securing dissolution of marriage. The moot question which was put forth in the editorial was whether Supreme Court's observations give an impression that the armed forces may go ahead with disciplinary action for misconduct of adulterous acts as commonly understood in the common parlance without a reference to Section 497 of the IPC under their special legislations, which were, to name a few, the Army Act, the Navy Act, and the Air Force Act. Now, subsequent to this particular the adultery judgment, the Rajasthan High Court came up with a decision in the case of Mahesh Chand Sharma versus State of Rajasthan and others, wherein the High Court has held that no employer has the right to morally police someone even if they were an inspector in the Rajasthan police. Further, there came a decision from the High Court of Gujarat in the case of Mahesh Bhai, Burji Bhai Damar versus State of Gujarat and three others, wherein it was the Honorable High Court quashed and set aside the dismissal order of an armed police constable arising from allegations that he had developed illicit relations with a widow, which amounted to misconduct. The editorial states or asserts that the Parliament enjoys wide-reaching powers under Article 33. However, the same comes with a caveat of so far as to ensure proper discharge of duties and the maintenance of discipline among the personnel. Hence, the editorial states that a thorough reading shows that the case of or the judgment of Joseph Shine of 2018, it does not inhibit the parameters of departmental proceedings, and a common thread of judgments also holds that the conduct of the individual who is accused, it should not be unbecoming of a government servant. The legislative intent of Article 33 of Constitution is also similar, the editorial adds, while further stating that the right to privacy of police and army personnel, it cannot be taken away unless the same has some direct relation with the discharge of their duties honestly. Now let's proceed with the news updates for today. The first is with respect to the Oscar Awards for this year. The movie Everything Everywhere All at Once, it has won the award for the Best Picture, while Brendan Fraser and Michelle Yeoh, they have won the award for the category of Best Actor and Best Actress respectively. The Finance Ministry has brought about amendments under the Prevention of Money Laundering Act of 2002 in order to bring virtual digital assets under its ambit. The Indian Army on Thursday installed a 100-foot tall national flag in the landlocked hilly district of Doda in Jammu province, while the next update is coming from the state of Maharashtra. The state will introduce the fourth women's policy to give more opportunities to women by considering their issues. As per a recent report by PhonePe and Boston Consulting Group, it has concluded that India's digital payments market, it will grow more than triple from $3 trillion to $10 trillion by the year of 2026. Rohit Java, he is named as Sanjeev Mehta's successor as Hindustan Unilever Limited's next MD and CEO. He is to take over as the MD and CEO of this company from June of this year. He is currently the Chief of Transformation for Unilever in London. Now let's proceed to the two legal updates that we have for today. First of which is about the petition governing same-sex marriages. The center has submitted its 56-page affidavit stating that heterosexual marriages is the norm. Marriage is the norm. The center additionally said that the union between two people of opposite sex is culturally, socially, and legally ingrained into the very idea of marriage, and the same should not be diluted by judicial interpretation. This affidavit was filed in the case of Supriyo alias Supriyo Chakraborty versus Union of India. Next update is coming from the High Court of Jammu and Kashmir. When issuing authority verifies experience certificate, counter-signing authority's denial won't lead to termination without inquiry, the Honorable High Court holds. The Jammu and Kashmir High Court has held that mere denial of counter-signature on a certificate in absence of proper inquiry, it will not warrant a major punishment, such as termination of service. This was held in the case of Rokade Santosh Sandashya and another versus Union of India and another. That's all we have for today's TNA. In case you want to have access to free study materials provided by LawSikho and also the slides which are used in this particular TNA, please join our Telegram channel using the link which is given in the description. You can also scan the barcode which is given below. Thank you for being with us. Have a good day.